Yeah, he's definitely going to need a waiver if he has to pay an appeal bond just to guarantee the state gets its money when his appeal inevitably fails. How's he supposed to afford more of those fake license plates?
On the record in 2024, TR 617, State of Kansas versus Abel Estrada. Paul E. Dean for the state and Mr. Estrada appearing in person and pro se. The defendant was found guilty February 14th, 2025, ordered to pay scheduled fine in 108 within 15 days. And what have you done about that, sir?
I submitted the notice to appeal.
Okay. And have you done anything to perfect that appeal with the Kansas Court of Appeals?
I'm waiting. I literally just spoke to the court record, and they send it in, and the next thing is we're just waiting for the plea.
All right. First of all, I'm not making if Mr. McClendon has not withdrawn, I'm having him do so now because we do not, to my knowledge, pay for appeals of illegal tags. You'll need to be responsible for that yourself. And it's not enough just to file the notice that you intend to do it. You need to actually do it. So are you going to be representing yourself or hiring an attorney on that, Mr. Estrada?
I would like to get an attorney.
Well, you're going to have to hire one because throughout the trial, you kept insisting that if I'm remembering correctly, you didn't want an attorney. Isn't this one where I made Mr. McClendon stay on as kind of a backup counsel?
That's correct, Your Honor. He was essentially became standby counsel, and the court granted Mr. Estrada basically special consideration on this matter, as this is not even an offense that's eligible for court appointment, as it does not carry a sentence that exceeds 6 months.
Oh, yeah, yeah.
And I thought the court, I was going to double check the journal entry. I was thinking Mr. McClendon, maybe even on the last journal entry, had been allowed to withdraw, but there was delay in me getting the paper, those journal entries to the county attorney's office, because I had a few to complete after that day. So they had not all been emailed in. So I think that they might still be in the process of being e-filed, because then the following week as I recall correct, I didn't travel to Greenwood County because of all the snow.
Okay.
I did my meeting with the commission via Zoom. So, but today the court's ordering that Mr. McClendon is withdrawn. Mr. Ray was directed to, or advised he should perfect his appeal.
And I'm going to set his pay or appear over 30 days to see if, and remember, you were to pay a $15 or $158 cash bond. Did you do that when you filed your notice of appeal?
I'm sorry. Can you repeat that again?
I had ordered that if you appealed, you had to pay a $158 cash bond. Did you pay that appeal bond?
No, I didn't, but I was trying to get a waiver.
Right to separate attorneys independently said they couldn't represent Mr. Estrada because doing so would force them to take a legal approach they believe violates their oath to the Constitution. If you walk into a room full of lawyers and judges and think they're all constitutionally incompetent, it might actually be.
Well, I haven't seen anything about a waiver. Mr. Dean, have you seen anything about a waiver on his appeal bond?
No.
Well, I would deny any appeal bond. Mr. Abel, the facts in this case were very straightforward. You'd made up or bought a made up alleged tag that wasn't even close to being a legal tag. We spent a lot of money trying it, and I say a lot of money because I made the defense attorney stand by, even though you didn't want an attorney. Now you say you want an attorney to appeal it. Well, I'm sure not going to appoint one to appeal it. And if you cannot even afford your $158 appeal bond, I'm wondering how you're going to afford your attorney if you can even find one to take this kind of case on appeal. I would venture to suspect that it's never been done before, but if you think you can get it done, you're welcome to, but I am proceeding that until that appeal is perfected, you still owe $158 fines and costs, and you need that to pay that appeal bond. So I'm going to review this in 30 days, and you better have it all figured out, or you better have it all paid.
I actually started the process, and I send the appeal notice, and I actually send I requested the what's it called? The report. Oh, the journal entry from Mr. Dean office, but I haven't got it because the journal entry reflects $50, but I never got it. I never seen the charges or the journal entry. I'm trying to get all the information in.
That's all great, Mr. Estrada. The journal entry is being filed. Your Honor, I don't know that at least the state's not particularly interested in his steps to appeal. That's for him to figure out on his own. I do have one item to correct on the record, Your Honor. I think probably it's proper to note that Mr. Estrada was wanting counsel. However, both court-appointed counsels, Mr. Paul and Mr. McClendon, both believe that Mr. Estrada was also wanting them to violate their oath as an attorney and make arguments
that is incorrect.
Don't interrupt, please.
And make arguments in violation of both the U.S. and Kansas Constitution was the specific statement both attorneys made to this court.
Yes. So
that was all. I just wanted to correct it because he was asking for an attorney, even though, quite honestly, the case doesn't qualify for court appointment.
Oh, thank you for correcting the record.
The court still did grant him that an attorney, but the attorney's based. Mr. McClendon became standby because he believed that the arguments were not supported and were in violation of his oath.
All right, thank you.
30 days to pay the fine, post the appeal bond, or come back to court and explain why he shouldn't go to jail. Now we move on to the next hearing, where no-nonsense Judge Ricky shuts down a sovereign citizen before he even gets a word.
And it looks like from my docket notes, he was just ordered to pay 108 court costs. It says scheduled fine, but isn't this a misdemeanor?
I just asked for the basic fine. What I refer to as basic fine, it's not really a scheduled fine, but it was $50 because he did actually have it. He just refused to
put on his car.
Display it.
That's right. He refused to put it on his car, put on that cardboard.
So despite all the rigmaroles, I treated it just as any other case.
Okay. All right, Mr. Estrada, we're going to make you come back for another pay or appear in 30 days. Missy, when is that?
March 28th at 11 o'clock.
All right, March 28th, 11 o'clock. We're going to review this and see if you've paid your case and moved on, or if you're going to keep fighting it and never mind. All right, but I understand, Mr. Estrada. What is it you're appealing? The fine and court costs, or are you appealing the verdict?
I'm appealing the verdict.
Okay. And you want to maintain your argument that cardboard tag was legal. The tag that you made was legal.
Yes.
Okay, all right. I just wanted to make sure I knew what we were doing here. All right, I'll see you back here March 28th at 11 unless you paid your $158 balance. Thank you, sir.
Yeah, I just wanted to know, where do I get the report, the journal entry from Mr. Dean?
It'll be with the court. Look at the court.
Clerk of the district court is the keeper of journal entries.
You mean the court record?
The court records are all through the clerk of the district court.
Okay, thank you.
They're the public record holder. Yes, sir. And that's about all I can advise you. I'm not going to help you practice your appeal.
Asked. KSR 224.53 clearly states it's the court's duty to inform you of your right to counsel and assign one from the Indigenous Defense Services panel.
Jesse Travis McLaughlin.
Yeah.
This is State of Kansas versus Jesse Travis McLaughlin. It's case number 2024 CR 397. Mr. McLaughlin appears from a Hutchinson Correctional Facility Zoom location. Brett Sweeney appears for the state of Kansas. Mr. McLaughlin, I have before me a charge of battery against a law enforcement officer, a level 5 person felony. Since a felony is involved, we will not be asked to plead at this time. Rather, a preliminary hearing scheduling will be made before your assigned judge, which is the Honorable Jan Satterfield. Judge Satterfield's next docket for that purpose would be April 7, 2025, 2:30 p.m. You must fully participate by Zoom in Judge Satterfield's docket at that time, April 7, 2:30 p.m. I trust, Mr. McLaughlin, that you, being in prison, don't have the financial resources to hire your own lawyer.
That's all right. I can represent myself.
Okay, well, you can take that request up with Judge Satterfield. At this point,
Every
in
man
the
must
limits of
speak for
caution,
himself, Your
I will
Honor.
appoint a lawyer, and then you can, before Judge Satterfield, properly conduct a proceeding if you really do want to
Point of
represent.
order. What gives you jurisdiction to appoint a lawyer over me?
I have statutory authority to do so.
I'm not a sovereign citizen demands the court establish jurisdiction and jurisprudence as a point of order, only to be shut down immediately. Jurisdiction affirmed, attorney appointed, $5,000 bond set, and the next hearing scheduled. With Judge Satterfield, despite his objections and attempts to derail the process, the court moves on. Now that we're done with the solo sovereign in Kansas, let's head over to the Neanderthals wandering the streets of Michigan.
So, Mr.
So
Kaufman,
what
I'm
gives
going to
you
appoint a lawyer at this
what
point.
gives you jurisdiction over me? You must establish jurisprudence as a point of order.
I'm not going to play your sovereign citizen gibberish game.
I'm not a sovereign citizen, sir. I'm
All
not a
right.
sovereign citizen.
You sound like one.
Well, I'm not.
All right. I assure you I have jurisdiction. So we've got a court date set before Judge Satterfield. I'm going to appoint James Watts at this point to represent Mr. McLaughlin, noting he's made a request to represent himself. Again, that's to be a matter taken up fully before the assigned judge, Satterfield, at the hearing date on April 7 at 2:30 or some later time. And the court will set a $5,000 cash or professional surety bond, though obviously it's not going to affect his current incarcerated status. All right. Bond set, attorney appointed, court date established on Judge Satterfield's calendar. Anything else we need to address at this time, Mr. Sweeney?
No, Your Honor.
Mr. McLaughlin? Apparently not.
Yeah, you need to address a point of order. As a
I've
first
addressed
point
all of
order
the
in
points
court
of order
order,
that I'm
first
inclined to
thing
address
you must
today.
do is establish
Mr.
your
McLaughlin.
jurisdiction.
The McLaughlin matter is currently in recess, and we'll move on to another matter on the docket.
I object to moving on in any manner.
Objection noted and overruled, Mr. McLaughlin. All right, let's move
Request a
on.
copy of-
Then.
I
Thank
request
you
a
to
copy
the
of the
Hutchinson
minutes,
Correctional Facility.
transcripts, these proceedings.
We can go ahead and take him off the meeting at this time.
Really the heir apparent to the Kingdom of Morocco. Someone better let the king know. His prince is back in jail. Also, here's a video of me at a Moroccan castle in central Portugal, which probably means I have visited more Moroccan heritage sites than any of these clowns claiming royal blood. From now on, just call me
Individual and sir, what is your name at the jail?
I'm Roman Cabil. I mean, I can place my status on the record if you like.
Yeah, hold on one sec. Yeah, I'll get to you. 1 second. I need to look over some things. Are you representing yourself?
No, sir, I'm not representing myself. I'm presenting
Okay.
myself.
Okay. I mean, do you have is a court appointed attorney going to be speaking with you, or are you going to have a retained attorney?
No, sir.
The calling case Tom King 25 William Boy 00474 in the matter of Roman Curtis Kendall. Mr. Campbell, would you please state your name for the record?
Yeah, I like to state
Just tell
my
me your
name.
name. Yeah, go ahead. Yeah, all I have to do is say it.
I'm Roman Curtis Kempill, a natural person for life.
Okay, let me ask you this question, Mr. Campbell. Let's try not to talk together. I mean, I'm going to allow you plenty of time to talk, because I have to. But are you representing yourself here today? You don't need an attorney, or you want an attorney?
No, sir, I'm not representing myself. I'm presenting myself. I don't need another man to present.
So are you presenting yourself? So you don't want an attorney, you're presenting yourself here today. Is that correct?
Yes, sir.
Okay. All right. Thank you, sir, for that.
You're welcome.
You're charged with domestic violence, as I've indicated. MCL 750.81, it carries a maximum penalty of 93 days in jail, possible fines of $500 and/or both, not including any court costs. I am going to enter a plea on your behalf of not guilty on this offense. You will be given an additional, and you're also charged with refusal for collecting fingerprints and data, which the court is ordering that you do that. As I've indicated, I'm entering a plea of not guilty on your behalf for this matter. I'll indicate that you're self-representing at this time as well. I do have some other conditions for you before I set bond. You're not to have any direct or indirect contact with Marissa, M-A-U-R-I-S-S-A Smith. You're not to return to the premises known as Celeste Road.
That's my home.
I'm gonna keep going, and then I'm gonna take all your questions at the end. So no problem. It's not, just hold on to that question. That's all. You're gonna have plenty of time to talk at the end. So do not return to the premises known as Road, West Bloomfield. You will not assault, beat, verbally harass, intimidate, or threaten any potential witnesses. Person may appear for all court proceedings. Do not leave the state of Michigan without permission of the court, and immediately notify the court in writing of any change of address or phone number. You need to provide the court with a valid address within 24 hours of your release. Do not leave the state of Michigan without permission of the court. You will not possess any firearms or other dangerous weapons. You shall refrain from using alcohol, any form of THC, illegal drugs, or using any medication. You must contact pretrial services within 24 hours of your release. That's at the 48th District Court in Bloomfield Hills. Pick up no new criminal offenses. And I understand you're self-representing yourself here today. The court will set a bond in the amount of $1,500 cash surety, no 10%. Sir, do you understand your bond, what I've read off to you, your bond conditions?
Yeah, I understand all of that, but all of that.
Okay, now I'm gonna take your questions right now. Thank you very much. So what question do you have for the court?
Can I place my status on the record, sir?
Absolutely, sir.
Okay, I'm Roman Curtis Kempill. I'm a natural person in full life, in propria persona, sui juris serveritis. My nationality and citizenship being Moorish American national, unconditional heir, apparent vessel for the Moroccan Empire.
That's definitely someone we'll be seeing again soon. Now let's head into our final hearing. Next.
At North America, North Gate, Turtle Island. I come under protection by way of Treaty of Peace and Friendship, 1836, between the United States Service Corporation and the Moroccan Empire. I also would like everybody else that's involved with this matter to place their status on the record, so that it can be noted. And also, I'm not representing myself. I'm presenting myself. Not only that, I'm not standing a surety to Roman Curtis Kempill in all capital letters, ins legis, corporate entity. So that be noted for the record, please, sir. I also reside in domicile at. That's my address. That's my home. The defendant, witness, or whoever that is, Marissa, she doesn't live there, and so that's where I was kidnapped from. That's my home, sir.
Okay, and I will allow you to go back there one time and one time only with a police escort to obtain some minor personal property. That's with a police escort only. Otherwise, you cannot go back to that location.
They weren't, because child support is a statutory obligation, not a contractual one. You may have signed something acknowledging your responsibilities, but that was just a recognition of your legal duty as a father, not the creation of some contract the state could breach.
You have another court date coming up. Your next court date is going to be your pretrial date. That date will be provided to you prior to you bonding out. If not, you're going to have to contact the 48th District Court in Bloomfield Hills. Other than that, best of luck to you, sir. Officer, we're all set here. Thank you very much for your time.
If I could, Your Honor, we would like the refusal of the booking process that he not be released until that is completed.
Absolutely. He must submit, as it relates to the booking, he must submit to the booking processing in this information, including fingerprints, which is the biometric data. He must provide that information prior to release as well. You're all set, officer. Thank you.
So I'd like one more thing, sir. I'd like to invoke my treaty right to consular jurisdiction. I've been asking someone to be that's competent in the notification and access manual, and I haven't been given that right. My rights have been violated as far as all of that's concerned also. So
okay, make sure you mention that to the judge when you see the judge. So thank you very much, sir, for that. And officer, we're all set.
Thank you, Your Honor.
Okay, must submit the biometric fingerprint data prior to release.
What do you have to add to it?
I'm wondering if you got those check stubs that I've entered in.
I didn't get any check stubs.
So
yeah. Wait a minute. I did get some check stubs. Yes, you were the one that did have them. Yeah, I had a question on those because you got 2 support notices on each stub. So do you have more than one case?
Yes, sir.
Okay, how many children do you have?
2.
Okay, this one and another one?
Yep.
Okay, because I was trying to figure out, I have a feeling that what's happening is they are maxed out on how much they can take out of your checks. The reason that you keep getting hauled in is because you're not paying the full amount of child support.
But at the time that they was taking the money out of my checks, they issued the warrant.
Right. If you owe $100 and they only collect $70, you're gaining $30 a month in arrears. And once the arrears hit a month, well, that's why I was asking, because the amount of child support that is are these weekly checks or monthly?
Weekly, sir.
Okay.
It's 440. It was receiving that, and at the time,
and how much did they say that you owe?
Just now, recently.
Yeah.
They said I was in arrears is 5,000.
Okay. Yeah, because I have a feeling that's what's happening. Now, you have the right to have this child support reviewed at this point in time. It's been 3 years since the last order, so it can be reviewed for you.
But my whole thing is, I wasn't paying because last year, April, they got a $5,000 check on my behalf.
From whom?
From an employer, from a settlement, which was from an employer.
Okay, and they confiscated all 5,000?
Yep, it was.
Okay, and that should have gone against any arrears. Now, their next question would be, are you sure they got it?
Child support?
No, the $5,000 check.
Child support got that $5,000 check.
Are you sure they got it?
Yes, I'm sure they got it.
Because what I would do if I were you is ask for an accounting of the case to make sure they got it. And accounting will give you a computer readout of every month that you owe and every payment that's been made. And they do it in writing. So if you write them and ask for an accounting of your child support, because some of this stuff will not be in the court file. The court file is a public file. So the court does not know how much your arrearage is unless they apply for a show cause. Okay.
Okay. And I haven't been paying recently because I was under the impression that the obligation is $445 a month.
Well, it looks like how have you not been paying? Are you not employed anymore?
I'm at work right now.
Okay. Well, it's because the employer automatically takes it out.
Right. I just started this job, and
Okay. Then you have to notify the front of the court what job you changed to, so that they can apply it to the appropriate. Because they issue an automatic income withholding order. Again, that does not go in the court file because it contains some very specific information about you, and you don't want that public information.
This is what I'm trying to say to you, sir.
Hmm?
They received $5,000 last
And I told you what to do to deal with that.
April.
Yeah.
I was under the impression cover the rest of the year. I did not know that they
they don't cover anything forward. They only cover things currently owed.
Right. Okay.
They can't hold money forward. If they have an overpayment within 48 hours, they will send you back a check for the overpayment.
Okay. Well, they still was